Okay, it's Emily, your everyday light worker. I am back to get into the really complex language that institutions use so that they don't really have to talk about racial discrimination. So, the federal government prides itself on creating really long, drawn out, complicated systems to deal with racial discrimination. Okay, but can you get through this process? Look at this process. Now, this is an acceptance letter that was given to one of my clients who had a really simple case of sexual harassment and discrimination based on race. So, this was a black woman who was an administrative assistant at the Department of Energy. She enjoyed her job, didn't have a problem with her job, always had received good employment evaluations at her job. But one of her colleagues, who was a black man, was always harassing her by commenting on, her body, her breast, her buttocks. This is clear discrimination, sexual harassment discrimination at that, which is, a very kind of unique type of discrimination. And just trying to pressure her into going out with him. Now, and so it was a simple complaint. I, was trying to do my work, and my colleague wouldn't leave me alone. He's constantly harassing me, and I complained to my supervisor. And after that, so many bad things started happening to me. People wouldn't talk to me. My security clearance was taken away from me. My work was taken away from me. I was treated as a pariah. And a lot of times this really does happen if you complain about sexual harassment. So, women beware. If you complain about sexual harassment, this might really happen to you. But she was a fighter. She retained me as an attorney because she said, this isn't right. And I agreed with her, it wasn't right. So I agreed to represent her. And the first part, her part, was filing the complaint. And she did that in a timely manner, and then after that, she didn't get any resolution through any informal processes, so she went to the formal process. We had already written up the complaint letter formation, the complaint form. We had already written that up, so we sent that to the Department of Energy's Office of Civil Rights, and in response to that, she received this 10-page letter of acceptance. So this is a well-written letter of acceptance, and I'll explain why it's so well written for the federal government. It's well written because it's a little too well written. It's 10 pages. It gives you a lot of really complicated and intimidating information that would cause a typical employee to be like, you know what, just forget it. I'm not even going to go through all of this. So look at how the letter starts. Notice of acceptance and partial dismissal of complaint of discrimination. Bifurcated mixed case complaint. Bifurcated mixed case complaint. What does that even mean? If you're an employee getting this letter, you're already like, what does that even mean? So, it says, this correspondence is in reference to your client's formal complaint of discrimination, which was filed by you on behalf of your client and was received by this office via email on August 19, 2019. So notice you're going to see dates all throughout this letter. Dates are very important when you're talking about discrimination, anything legal. The time and the date that something happened is always going to be really important because in the law you always have to be mindful of, is this timely? Does the court or whoever's listening to this complaint have jurisdiction? Because if it's too much time has passed, they don't have jurisdiction. But claim number 1. Complainant alleges she was subjected to unlawful discrimination on the basis of race, black, and sex, female, and reprisal. When? And then it goes into what happened to her. Her security clearance was taken away. Then they put in this little footnote for clarity of record. They talk about when the complaint was filed and how they're going into historical background information. This is how the feds use a lot of jargon to make what's really simple really complicated. So they talk about her security clearance. Then they say this is the heart of it, what I'm talking about, the sexual harassment. That's claim number 2. Complainant alleges that she was subjected to unlawful discrimination and or harassment by a management official on the basis of race, black, sex, female, and reprisal, that's retaliation, when the following events occurred. So this is a civil rights office that really knew the law. They knew what they were doing. They had gotten incredibly exceptional training on how do we do this when someone says they've been complained. How do we write this up so that it will jump through all of the federal hoops that it's required to jump through? So the agency needs to, if you're saying that you've been harassed, the agency needs to jot out every single line of the harassment. And so this agency did that correctly. All of the agencies don't do that. Now, the reason you need to have all of these lines of this is the harassment and the dates is because it needs to be investigated. And if you don't list it out, the investigator who gets the complaint, they're not going to ask about it. They're not going to investigate it. And it will look like, nothing happened to you. So if you don't have all of this, what the investigator will ask the management official is, this person says they were subjected to unlawful harassment, hostile work environment on the basis of race, sex, or female, and retaliation, reprisal. Did you do that? And of course, the person is just going to say, no. And so then it becomes, his word against her word, and it's really just, it's a joke. It can really become a joke. But when they articulate every little thing out, then the complainant really has got an investigation, something that can be investigated. So, but just because you say that doesn't mean they're going to accept your claims for investigation. So there can be a lot of reasons that claims aren't accepted for investigation, but most of the reason is that it is not timely. So when you're talking about these federal complaints of discrimination, you have to make sure that what you are putting down is timely. It has to have happened within a certain time frame, usually close to when you file that complaint. If it's not close, it's not going to be timely. It's not going to be accepted. So this was not accepted because the civil rights agency is like, hey, wait a minute. There's another agency that deals with this security clearance stuff, and it is the Merit Systems Protection Board. Now, we all know that federal employees have a lot of rights, and the federal government itself is annoyed that it has given federal employees all these rights because it does really make them really hard to terminate their employment. And the idea behind this was that people should not be terminated for just doing regular federal government work. They should not be terminated. And what they're doing, it has to do with how the business of this country is run. If you just terminate them, then that's unethical. Our system was designed to prevent this. Does it prevent this? Kind of. It depends on whether or not the agency is going to follow its own ethics and policies. There are some agencies that do. There are some agencies that don't. So it depends. But and so the letter goes on and on and on. One of the things that it says is your client, look at this, your client must name as the defendant in the complaint the person who is the official head of the Department of the Energy, Department of Energy, identifying that person by his or her full name and official title. So first of all, that's intimidating. It's like, if you really are going to go through with this, we're going to make you put this person's name on a piece of paper, call them out, and most people would find this just really, really intimidating, and they don't want to do all of that. So they, explain that so it's just telling you what all of your rights are with regard to this, if you should want to pursue this in federal court. Most people do not. So, But they tell you you have all these rights, and then they tell you about how difficult it is going to be to collect anything or get any kind of justice for the unfair discrimination that you have received. So the first thing they did that was weird is they partially accepted and they partially dismissed. So like I said, they don't have to accept your claims. They can dismiss your claims if it's kind of in the jurisdiction of another office, and that's what they did here. But they said partially, claim number one is partially accepted and partially dismissed. And then it gives the reasons. And then it goes into this long, I mean, look at this, pages and pages of very legalistic language that a typical employee that works for the federal government is not going to understand. Then they tell you what you need to do if you want a hearing before the EEOC, and then it will tell you whether if you don't want that, you can request a final agency decision. So I have discussed this in my other videos. Then it gives you what all of your rights are, what you have to do, when you have to do it. And this is just really, really complicated stuff that legalistic jargon, which all of this is being done to basically prevent the employee from talking. And I love this, notice to complainant seeking compensatory damages. So it tells you all the stuff they're going to do to you. Well, first it tells you what kind of damages you can request, because you can't even request. People think they're going to get millions because they've been subjected to this kind of discrimination. I can tell you right now, you absolutely are not going to get millions from the federal government. The federal government will tell you if you're saying that you deserve money for what you've experienced, that you've lost wages, that you were humiliated or whatever, you can only get this much money in damages, and you have to prove it. You don't have any proof, you're not getting anything. So, if you're saying that you went through emotional pain and suffering, inconvenience, mental anguish, loss of enjoyment of life, injury to professional standing, okay, they're saying you can say that these things happened to you, but you have to prove it. And that tells you how you can prove it. You get statements from family members, friends, healthcare providers, counselors. The thing is, people don't like to get involved in litigation. So it's really, really hard to get this kind of evidence, even if you do have it. And then they want to get all into your medical record, and complainants hate that. And then it says that your client must establish a causal connection between the alleged discriminatory actions and any resulting physical, emotional, and other harm your client claims has occurred. So they really make you jump through a lot of hoops before you can get any kind of damages. Then they say that your client has a duty to mitigate her damages. So I had another person who, for example, her knee was damaged because of a supervisor just being like, I think he was just a psycho. He just wanted to hurt people. So her knee was in a lot of pain, and she needed to, use a special entrance to help minimize that pain. But the supervisor didn't want her to do that. He wanted her to walk like 1,000 feet around to another entrance to open the door. And as a result, her leg got really, really damaged, for real. And because of the particular EEO departments that she had to work with within the federal government, she got nothing. She got her complaint dismissed without it ever really being heard. And, that does happen. A lot of this with your complaints is just the luck of the draw. Do you get in front of the right EEO counselor? Do you get the right administrative law judge? Do you get the right oversight agency that will actually do something? And it is just the luck of the draw. And I let my clients know that, when people file these complaints, they usually do it because they really, really are being made miserable at work, and they feel like they have to take a stand. They have to do something. But at the same time, this language, this is at the very beginning of the process. To navigate this language is an absolute nightmare. And it just takes so much time and so much energy. And this is the way institutions don't really let you talk about race or sex or any kind of discrimination.